Yeah, I think we should maybe get started. Good afternoon, everyone. Thank you all for braving the cold and the snow to come here today. And thanks to everyone who's joining us online. Before we begin, the Center for Constitutional Studies acknowledges that we're gathered on Treaty 6 territory, a traditional gathering place for diverse Indigenous peoples, including the Cree, Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Ojibwe, Saulteaux, and Anishinaabe, Inuit, and many others whose histories, languages, and cultures continue to influence our community. We also recognize the harm that colonial institutions have done and remember that there were centuries of governance and education on this land before settlers arrived that continue to this day. We honor and reaffirm our relationship with one another and the land we are on. We hope that our work contributes to dismantling systemic barriers to legal education that First Nations, Métis, Inuit, and other marginalized people face. I am Aubrey Abaya, and I am the Public Legal Education Coordinator at the Center for Constitutional Studies. If you're not familiar with the center, we are a public legal education. Hopefully you are now. We are a public legal education and research hub that's housed here at the University of Alberta, Faculty of Law. So our commitment to public legal education is why we're delighted to bring you this talk today, 17 going on 23, Sentencing Children to Life in Canada. Briefly, housekeeping wise, we will have a 30-ish minute lecture and about 15 to 20 minutes left at the end for Q&A. So maybe write down your questions if you have them for the end. And if you're joining us online, please put your questions in the chat. So our speaker today is Debra Parkes, a professor at the Peter A. Allard School of Law and the chair at the Center for Feminist Legal Studies. She was a member of the Faculty of Law at the University of Manitoba from 2001 to 2016, where she served a term as Associate Dean from Research and Graduate Studies from 2013 to 2016. Professor Parkes' scholarly work examines the challenges and possibilities of addressing societal injustices through rights claims, with a focus on the criminal justice, corrections, and workplace contexts. The lens she brings to this work is feminist, intersectional, and socio-legal. Professor Parkes takes a particular interest in the incarceration of women, the limits of prison reform, and the framing and adjudicating of prisoner rights claims. With funding from the Social Sciences and Humanities Research Council of Canada, Professor Parkes has examined mechanisms for oversight and accountability of imprisonment in Canada, and she's now leading a new SSHRC-funded project examining life sentences in legal social contexts, which we will hear about a bit about today. Professor Parkes supervises graduate students in the fields of sentencing, penal policy, and the criminalization of women. I can personally attest to that contribution, as Professor Parkes was, as a graduate student, she was my second reader on my thesis. So I want to personally thank her for reading my incomprehensible drafts and passing me in the end. So with that, let's welcome Professor Parkes.
Well, thank you so much, Aubrey. And yeah, I mean, it's such a delight to be here and to have been invited by Aubrey, because I had the opportunity to get to know her and to learn from her in the research she was doing on youth criminal justice and at UBC. So it was a really nice connection when she invited me to come and give this talk, and I was able to speak to an area that we have kind of some research connections in. And I'm, a big fan of the Center for Constitutional Studies and the kind of work that the center does, and especially the focus on public legal education, as well as more scholarly work. And I think that's really important. Also, just I want to say before I start around the land acknowledgement, I like that you included kind of a harm acknowledgement in there, because that's something that I think about and reflect on in my own work, that where I live is on the unceded territories of the Musqueam, Squamish, and Tsleil-Waututh peoples in what is now, I live in what is now New Westminster, on the coast of on the banks of the Stolo, the Fraser River. And And in the work that I do, and that I'll be speaking to you, and those of you who work in the criminal legal system or criminal punishment system, you will be confronted daily with the ongoing harms of that imposition of the colonial legal system, and the role of the criminal law in perpetuating mass incarceration of Indigenous people. So I want to be accountable in my work to those realities, and to be pushed to make sure that the work that I'm doing is actually trying to address those things in ways that are actually useful, and not simply for my own scholarly advancement or interest. So I encourage you to be part of that process of holding me accountable in that regard. A note about the title too of my talk. The words 17 going on 23 are the words of a trial judge here in Edmonton. They used those words to describe a young person being sentenced for second-degree murder in a case called DE 2008 decision. The young person was born in the Philippines and came to Canada with his family at the age of 6. At paragraph 17 of that decision, the sentencing judge said, quote, "The accused has been living on his own for approximately the last 3 years, having pushed his family and their values aside to live a gang member lifestyle." As one member of the assessment team that had assessed him said, he is 17 going on 23. The judge went on to say, in the result, there is nothing to suggest there is a lack of maturity or diminished maturity on the part of the accused. On the contrary, the evidence points to a maturity and sophistication beyond the accused chronological age, end quote. DE was sentenced to life in prison. That brings me to a note also about terminology. And you see that I use the term, when I gave the paper, when I gave the title to Aubrey, 17 going on 23, sentencing children to life in Canada. I've been vacillating between whether to use the term child or young person in this paper. On the one hand, international human rights law and advocates of children's rights, including in the criminal punishment system, insist on the term child to clearly demarcate a group of people whose rights have been systematically suppressed, diminished, and subsumed under those of their parents. I worry about the term young person or youth somehow sanitizing or hiding what is going on when a person under the age of majority is put in prison for their life. One of my arguments, based on a review of the case law, as you'll see, is that some young people are denied their childhood status, denied the assumptions and protections of childhood. On the other hand, though, I'm also influenced by the work of scholars such as Lisa Kelly, who challenged me in an earlier iteration of this for using the term child, and suggested I should use youth or young person when talking about teenagers, essentially the group of people that we're talking about here in terms of criminalization and imprisonment under the Youth Criminal Justice Act. We need to think about the implications of using the term child for this group, particularly when I, for example, and I think many others, want to insist on their agency, for example, to seek reproductive health care, contraception, abortion, and gender-affirming health care, areas in which the label child is, I think, weaponized to deny the rights and interests of this group of young people. So I guess in the end, I've largely settled on the term young person or youth, but you'll find that I may use the term child where it arises in literature, case law, or advocacy, and I'm interested in perspectives on that. So by way of overview of my time today, oh dear. Where do I, sorry, where do I, what should I use? Oh, enter. No, I did a thing here.
No, it's okay. I think you can just.
Oh yeah, there we go. Just go like this. No. Okay. Just like this. How do I advance the slides?
That is a
this?
good question, because I haven't been in this. Oh,
Does someone know?
It's working on one screen, but it's not working on the other screen. So
still waiting on an IT response from September.
there. Okay.
So what do I do?
Just click.
Click.
Yeah, just so it's that's
Okay.
the second.
Okay.
step, right?
Yeah.
Just click.
Yeah. So this is sort of the overview of what I'm going to touch on. I'll touch first on life sentences for young people as a human rights issue. More broadly, adult sentences for young people under Canadian law. The study that I've been doing on reported youth murder sentencing decisions from 2008 to 2022, observations from the cases, and some thoughts about the constitutionality or unconstitutionality of the murder sentencing regime for young people. And this is part of I need to say, SSHRC-funded research project into life sentences generally, where I have some other papers and ongoing projects. And this is my first foray into working around youth. So interested in reflections on what I'm finding. Okay, let's see if it's going to work now. There we go. This is that statement. Sorry, from the case that I talked about, the DE case. I meant to actually have that slide a bit earlier. Okay, life sentences for young people. At least 73 countries retain some kind of formal life imprisonment for people who are deemed children in international law. These severe sentences are a feature of common law systems such as the United States, United Kingdom, Ireland, Canada, but they are much less common in member states of the European Union. The fact that young people may be eligible for parole earlier than their adult counterparts does not mean that parole will be granted. And that's such a really important point I want to highlight throughout. In fact, in Canada, this is something I will argue is vastly misunderstood or ignored in the case law, sentencing young people to life. These sentences are lifelong, subjecting a young person to a future of stigma, parole supervision, and a reality of a return to prison at the discretion of a parole officer for having a beer, for being seen, being depressed. These are all things that can return you to prison on a life sentence. Adults, or I mean, they're all adults by the time they get to that point. By any measure, sentencing teenagers to life in prison is an extreme punishment with many documented harms, such as increased victimization, severe mental health impacts, and prisonization or institutionalization in one's formative years. It's a sentence that follows a young person for their entire lives, often bringing them back to prison for minor breaches of parole conditions. A 2015 report by the United Nations Special Rapporteur on Torture concluded that any kind of life sentence is incompatible with the human rights of a child, causing, quote, physical and psychological harm that amounts to cruel, inhuman, or degrading punishment, end quote. The UN General Assembly has urged states to prohibit all forms of life imprisonment for offenses committed by young people under the age of 18. Okay, I don't have time today to go over the history of the youth criminal justice legal system in Canada through the 20th century to the present, but it's a very interesting trajectory. But the current law passed in 2008 is the Youth Criminal Justice Act. Sorry, in 2003. In 2008, the Supreme Court of Canada decided a case called DB that challenged the adult sentencing provisions of the YCJA as violations of the charter. At the time, those provisions presumed that young people under 18 who were convicted of murder and other serious violent offenses would be sentenced as adults. There was a presumption. In the DB case, the Supreme Court recognized the presumption as a constitutional principle, the presumption of diminished moral blameworthiness of young people. That's recognized in that case as a constitutional principle of fundamental justice. And they overturned the reverse onus on the basis of that recognition of that principle. So now for a young person to be sentenced as an adult, the burden is on the Crown to prove two things. First, that the presumption of diminished moral responsibility for youth is rebutted in the instant case. And secondly, that a youth sentence would be not of sufficient length to hold the young person accountable for their behavior. So we now presume that young people have diminished moral responsibility, and we presume that youth sentences are appropriate. And so let's look at murder. For murder, the only adult sentence in Canada for anyone is the mandatory life sentence for murder, and with mandatory periods of parole and eligibility, which for adults is set at 25 years for first degree murder and between 10 and 25 years as set by the judge for second degree murder. So when a young when a young person is sentenced as an adult for murder, they receive a mandatory life sentence, but a lower period of parole and eligibility, between 5 and 10 years, depending on their age and the degree of murder for which they're convicted. They will be in prison or on parole for the rest of their life. By comparison, a young person sentenced under the YCJA for first-degree murder will serve a maximum of 10 years, only 6 of which can be in custody under the principles and requirements of the YCJA. Or for second-degree murder, a maximum of 7 years, only 4 of which can be in custody. Importantly, they will not be on parole, nor will they be subject to return to prison at the discretion of a parole officer for the rest of their life. So just a bit of background on the YCJA before getting into the cases, which I think is actually important to understanding what's happening. At the time the YCJA was enacted in 2003, Canada had a very high rate of youth custody. As such, a key objective of the YCJA as a whole was to reduce the use of courts and custody for the majority of young people. The Act has been really quite successful in achieving this decarceration objective for young people, at least for non-Indigenous young people. I would say the youth incarceration rates for Indigenous young people continue to be very high, and Indigenous girls in particular are incredibly overrepresented. I don't even like that term, but like mass incarcerated under the YCJA. But decarceration generally has been a very big success of the story. That's the story that's told about the YCJA mostly. However, there was a second objective at the time, prominent in the introduction of the YCJA and the debates around it. In the language of the government at the time, there was an intention to, quote, respond more firmly and effectively to the small number of the most serious violent young offenders, end quote, to address, quote, disturbing decline in public confidence in the youth justice system, end quote. Hence, the adult sentencing provisions, which again were presumptive when it was passed for a number of serious violent offenses, were kind of integral to this, I would say, compromise that was reached and in passing the YCJA. So on the one hand, there was a kind of welfarist, community-based, evidence-based response to young people. But on the other hand, even though it ran contrary to the research and the primary thrust of the legislation, we had a strongly punitive response for youth convicted of anything that falls into that basket of violent offenses. It was assumed in the academic literature at the time the YCJA was enacted, and certainly when DB was decided in 2008, that the imposition of adult sentences on youth would be rare or exceptional. One of the research questions at the heart of this paper asked whether this is true or not, specifically for murder. Spoiler alert, my research finds that this assumption was not borne out. First, I need to note, publicly available statistics do not give us the answer to my research question. There are simply no stats showing how many young people have been sentenced to life or to adult prison generally, nor any publicly available data on the number of convictions for murder by young people. To begin to fill at least some of that gap, my research assistants and I searched for and analyzed all reported cases decided after 2008 when DB was decided. And these are all the reported cases we could find where judges were considering whether to impose an adult sentence for murder or a youth sentence, and specifically for murder and specifically those cases. And it's for the years 2008 to 2022. We focus on those years since that's when DB was decided, and it was assumed, as I said, that these would be rare given the double burden on the Crown. So what did we find? We found reported decisions involving 102 young people being sentenced for murder between 2008 and 2022. And I should say that it's been impossible so far to triangulate with official data to figure out how many of the overall cases we have captured. But from our, and my research colleague, my colleague who I wrote another paper on, Jane Sprott, who's a terrific criminologist who does quantitative work, and I'm not the person who does that kind of work. She didn't collaborate with me on this paper, but she made some inquiries on my behalf with the research division at Statistics Canada. And based on those, we feel confident that this is a substantial majority of the cases. And I'm happy to talk in discussion about the challenges of doing, like, of our lack of data in Canada. It's actually quite shameful. And I think it impedes a lot of important policy analysis. Okay, so what I found based on the reported cases, the Crown sought adult sentences in 89 of those cases, 87% of the 102 cases. So the vast majority of them, they're seeking an adult sentence. And by adult, I mean life, because that is the only possible sentence for murder. The court ordered the life sentence in 62 or 70% of the cases in which life was sought, and 61 of all reported cases. Of the young people who were sentenced to life, the vast majority, 84%, were for single murders. These numbers show that adult sentences are not at all exceptional or rare for young people convicted of murder. While younger teenagers, so I should say that the regime only applies when you're 14. So you can get an adult sentence if you're between 14 and under 18, a day under 18, right? So the younger teenagers, the 14 and 15-year-olds, were a smaller cohort. They were not as rare, though, as one might imagine. 18% of the total cohort of cases involved 14 or 15-year-olds, with the Crown seeking a life sentence in 72% of those cases for 14 and 15-year-olds. We might expect the presumption to operate at its strongest in these cases, but the presumption was rebutted in more than half of the time, 54%. Again, it's small numbers, but I note that it's something to attend to. Just a bit about gender. We found 7 reported cases of young people who were identified as female in the reports, and of those, 2 were sentenced to life. I want to make a note on race, though. In many cases, there was no direct mention of race, but we were able to identify that 27% of young people were Indigenous and 20% were Black from just mentions, like in the case. A combined 55% of 55% of the overall cohort were Black, Indigenous, or people of color. And again, this number may actually be higher due to the lack of explicit attention to race in sentencing decisions. For Indigenous young people, the Crown sought an adult sentence for 80%, and 90% of those individuals got a life sentence. For Black young people, the Crown sought an adult sentence in 100% of the cases where we could identify that the person was Black, with the court sentencing 68% of the Black young people to life. In the case where race was not discussed or otherwise evident, the Crown sought an adult sentence. So the rest of them, presumptively white, but we don't know, right? And we just don't know, because it's not required that the court speak to that, and often doesn't mention whiteness, obviously. Not obviously, but as our courts operate, as our society operates. So in those cases, the Crown sought an adult sentence in 85, and the court ordered it in 54 of those. So less successful on the Crown's part in those cases. So these numbers, again, are small, but I think they raise significant concerns. And I think it's therefore useful to dig into some of the reasoning in the cases. I don't have time to talk about too much of that today, but I'll touch on a few points and my observations from the cases. The numbers show that the presumption of diminished responsibility has proven quite easy to displace. The nature of the offense seems to overshadow all other evidence in many of these cases. You know what happens when you have a high-profile case involving a young person or a group of young people, because often you have a lot of these convictions are parties to these offenses. And of course, in our law, we treat parties the same. Like, there's no separate offense for being a party to murder. You're just a party, and you get there is no discretion in murder for adults or anyone else to do anything other than give them a life sentence. And so the nature of the offense seems to overshadow other evidence. There's much to unpack in the way judges talk about maturity of the young person in these cases. Recall the case from my title and the language of 17 going on 23. In this and many of the cases, there is an effort by the court to emphasize how the teenager before them for sentencing is not really young. In the vast majority of cases, the young person's age was described in years, modified by months or even days, almost to a case. For example, a 15-year-old girl who was sentenced to life was described as just shy of her 16th birthday. In another case, the court referred to the then 17-year-old appellant who would turn 18 less than 3 months later. Like it's repeated in the cases. It's like 1 year and 295 days, 16 years and 295 days. Like it's really prevalent theme in the case law. Ultimately, I argue that the function of these provisions, as they're interpreted, with the discretion they give to sentencing judges, is to strip at least some kids of their childhood, to make kids into adults for purposes of punishment, to deny them their youth, their immaturity, to make that irrelevant, inconsequential, so that they can be punished in these cases for the rest of their lives. And race is relevant to this process. I draw on the work of Robin Bernstein and her work on racial innocence, in which she argues that in the US context, white middle-class notions of childhood innocence and immaturity have been mutually constituted by a negation of Black children's innocence and humanity. I also draw on Canada's history of the treatment and construction of Indigenous childhood, of the denial of the humanity and childhood of Indigenous kids through the centuries-long project of residential schools, rooted in constructions of Indigenous children as savage. At a normative and doctrinal level, I see the relative ease with which the presumption of youth diminished responsibility being displaced in favor of the full force of adult punishment for life as fundamentally at odds with the constitutional principle of diminished responsibility itself. While I think the science about brain development, including the way that the prefrontal cortex is not fully developed until many people are in their mid-20s, I think that's significant. And there's a lot of discussion about this, particularly in the US case law. There's very much a focus on the science and in the juvenile life without parole case law in the US. I worry about a justification of the legal presumption that focuses too much on capacity and on brain science. I see these arguments a lot, as I said, in the US, in the case law trying to challenge juvenile LWOP. But in fact, age is not just a proxy for capacity. I argue that the fundamental justification for this presumption and for treating young people differently from adults, and you see this in the case law, like including DB, it should be primarily rooted not in neuroscientific or psychological immaturity of youth, but rather, or at least very significantly, I think, about a more political and social understanding of youth marginalization and of societal obligations to young people. Something else we see, and I could say more about that, but I want to talk about some of the other observations from the case law. Something else we see in these decisions is the judges struggling to apply a law providing that a teenager must either receive a maximum sentence of 7 years or 10 years under the YCJA, or a minimum penalty of life in adult prison, but nothing in between. The gap between these two sentences looms very large and often seems to compel the judges to order a life sentence. You understand what I mean about that gap, right? It's quite significant, right? That the maximum you can give is 7 or 10 years, only 4 or 6 of it which can be in custody, or you have a life sentence. Like that's the only option. You can't give an 11-year sentence, like determinate sentence. You can't do any of those things. So one of the way the judges actually address this gap, and this is a really significant theme that I found in the cases, is through inflating the youth sentence by denying any credit for time served in pretrial custody, which can be 2 to 4 years due to the amount of time it takes to get to trial. This runs contrary to like principles. I mean, it's allowed under the legislation, but it's it's a unprincipled workaround to kind of en masse deny credit for pretrial custody for young people as a way to address the gap problem. Another observation from the cases is that adult sentences, I think the life sentence in particular, I think is essentially invisible and normalized in these cases. It's rare for the court to discuss what a federal sentence in adult prison would mean for the young person before them. When a judge makes this determination, it is simply assumed that an adult sentence would provide the necessary supervision and support that the young person needs. It is also assumed that the young person would likely get parole when they are eligible. Neither of these are accurate assumptions. And I see the invisibility of the life sentence as related to the normalization of these extreme punishments generally. And that's a theme in my work about life sentences more broadly. Notwithstanding the lack of any evidence of what is available or not for the young person in federal prison, which is usually the case, at least as these cases are reported and what the judge says was before them, these decisions regularly conclude that rehabilitation for the young person is more likely in adult prison, in part because there's going to be supervision on release, and they talk about that. The federal correctional investigator, the ombudsperson for federal people in federal prison, has reported, ultimately to no avail, on the lack of programming and support and the particular vulnerabilities of young people sentenced as adults. This does not feature in any of the cases that I read. It's also rare in these cases for the court to even mention that the supervision will be lifelong. They do talk about the need for some, like when they first get out, but there's no mention that this person at the age of 40 can have their parole revoked. And that might sound far-fetched to you. I can tell you it happens. It happens a lot, unfortunately. Yeah. The choice by the judge is often described as a maximum 7 or 10 year sentence under the youth system. As I said, some of which must be served in the community by law, versus essentially 7 or 8 or 10 years in prison before parole. That's kind of how it's described. It's like, well, we've either got like a maximum 7 to 10 or a minimum 7 to 10, and it's essentially the same sentence otherwise, kind of thing. Except that no, it's actually a life sentence, and there's no guarantee that the person will get out on parole when they're eligible. And I'll say more about that in a minute. There really is a lack of, actually I'll say more about it now. There is really a lack of publicly available data or any research on how these sentences actually function. But if you talk to advocacy groups, family members of people serving these sentences, and the individuals themselves, you'll see quite a troubling picture. And I want to just give a shout out to one of the only pieces of research or a firsthand account that you can find of someone who is living under a life sentence that was imposed on him as a 17-year-old. As a party to a botched robbery where someone else was the main perpetrator, is this piece by James Rustin, who is someone I know and have had come and speak to my classes, and I assign this to my students in my seminar. James has spent nearly 3 decades in prison. He did not get parole at the 7-year mark, and you can read about why. When he eventually did get parole, he's been returned to prison numerous times for breaches of parole conditions. Alcohol was never a factor. He went in at 17, remember. He never legally had a drink in the world. And alcohol was not a factor in the offense. He actually started to cope with going to Millhaven Institution as a very young person, first offense. He coped by consuming brew made in the institution and other drugs. There are drugs and alcohol in our prisons, and to the extent he ever had any issues with substances, they came from his time in prison. And by the time he got parole, there was no evidence of him having consumed or had any contraband of those kinds for years. Nevertheless, every time he gets out on parole, he has a condition to abstain from all alcohol. And so someone who went in at 17 gets out he was in his 30s when he got out for the very first time, not allowed to even taste a beer. not like this is what we impose on people on life sentences. And the vast majority of people who are returned to prison, you can find these stats on the parole board's own website, performance monitoring reports, is for breaches of conditions or parole, the discretion of the parole officer. For people serving life sentences, whether they went in as a young person or as adult, readmission or revocation of parole for violent offenses is 0.3% of all parole revocations for life sentences. 0.3%. Offenses generally, it's in the like 3% range, and if that includes every kind of minor offense too. So people are returned to prison for breaching conditions and for the parole officer deciding that they are somehow a risk because of mental health issues or those very discretionary assessments that they have to make. Okay, let me just conclude, and then I want to have questions with some thoughts on the constitutionality of these provisions. First, just a note about the nature of the life sentence when imposed on young people. The fact that it's discretionary, right? A judge can choose an adult or youth sentence, and they're supposed to presume youth. But that idea of it being discretionary has often been seen as sort of saving the regime from claims of unconstitutionality. Judge does not have to impose it, right? But that argument was challenged successfully in a different context in the Bissonnette case recently, right? Where you had a discretionary regime for the stacking of parole ineligibility periods. So making parole ineligibility periods consecutive for when someone is convicted of more than one murder. And that's discretionary. No judge is required to impose that sentence, but that does not insulate it from constitutional review, and particularly from Section 12, cruel and unusual punishment scrutiny. And in that case, the court found by majority that it was or was not, no, I can't remember if it was majority or unanimous, that it violated Section 12. So the discretionary thing is not a bar to it being unconstitutional. The life sentence for murder is also mandatory, though. Once one decides that an adult sentence, once one decides that the presumption is rebutted and that a youth sentence is not long enough, a judge must go all the way to life. And there's nothing in between, and that's I think a constitutional problem. Fundamentally, I think there's two kinds of potential claims. The narrower claim is that the current legislative regime for sentencing young people for murder, with its problematic gap, a real focus on that gap, violates the charter. And I think that's mostly a Section 7 kind of argument. And I can say a little bit more about that in discussion. But that focus on the gap, I think. A concern I have about that narrow claim is that how do you remedy that then? Oh, do you just give judges, discretion? Like, I'm someone who doesn't think it's actually very useful to put particularly young people in prison for or adult prison for long periods of time, but also anyone, quite frankly. And so I would not want the remedy for that to be like, making more more adult options. I'd rather have it be declared unconstitutional. And but I also think that may be how it gets remedied in any event. But I just worry about that from as a strategic kind of argument. I think there's a broader claim though, and that's that life sentences for young people are unconstitutional per se, in an argument sort of more along the lines of Bissonnette, and that where it was the nature of the offense. And in the Bissonnette case, you had the Supreme Court relying on the work of Ben Berger and Lisa Kerr, who people are familiar with their paper on the so-called 2 tracks of Section 12 jurisprudence and the idea of severity, sort of gross disproportionality in terms of length of a sentence, and all the mandatory minimum sentences, and those ones being declared unconstitutional because of the reasonable foreseeability that they would apply, that they'd be mandatorily applied in cases where they would be inappropriate. I think that argument actually there has purchase in this context too, again, because of that you have to go all the way to life. But also, I think this, more importantly, the methods track of Section 12 jurisprudence and analysis that Lisa and Ben point to in that piece, and that the court picked up on and ran with in many ways in Bissonnette, is this idea of a sentence that is unconstitutional by its nature. It's degrading, inhuman, problematic by its very nature, as the UN has concluded, and special rapporteur, and so I think there's work to do here, and I think there should be a constitutional challenge. I would want it to be the right case, and I've actually heard anecdotally from people that there have been a number of lawyers who've wanted to bring constitutional challenges. And what do you think happens in those cases? The Crown takes it off. Yeah, the Crown takes it off the table, right? So they get the sentence. And so that's what, so we haven't had any, and I'll, anyway, I think I'm gonna leave it there and open it up for your questions. Already. Okay. Oh, okay. Can someone keep a speakers list? Can you keep a speakers list? Because I don't want to lose track. We've got 1, 2, 3, 4. Can you keep? Well, yeah, I don't want to miss. Okay, I saw you first, but then I'm going to go over here. Yeah.
In reading the case law, did you find that there was maybe any odor that might lead you to believe that there's an appetite for tackling that gap issue? That the judiciary is finding it very challenging?
Oh yeah. Yeah, they find it challenging. They speak to it, and they sort of try to some grapple with it more openly, and probably some more kind of quietly. But they all make sure to, if they go with the adult sentence, try to provide enough reasons as to why they're going there. But I think it's definitely reluctantly in some cases, and there is this sense that the youth system is not long enough. It's not significant enough for murder, especially when you have these public outcry. And like I said, on a high profile case, often involving racialized young people. And I lived in Winnipeg, and a lot of these cases are there's quite a lot of cases from Winnipeg, and they're all Indigenous or Black young people. And so yeah, so I think they wrestle with it, and then they do this thing with the pretrial custody, where they say, to avoid having to oppose a life sentence, they shoehorn it in, and they say, we're not going to give any credit for pretrial custody, because that way he's going to still do, the time under the YCJA in custody, and then in the community. Yeah. Okay. Who should I go to over here? Okay. Anna, and then Florence. Yeah. And then I don't know your name.
I don't have questions.
Oh, I thought you did. Oh, okay. Sorry.
I really like what you said about how it's not just programming science, but it's more quality. And I got me thinking about the litigation and the part of people in the room who've written about it, current government's obligation to children who are like transition. And beyond the time that they're 18, help them make that. And so my question to you is, are life sentences ever justified? And if they are, is 18 the right moment to start treating?
Yeah. So I, my own view, like in my work, on the imposition of life sentences for adults, I also think they're they're problematic there too. And I think there's actually even some constitutional arguments there too as well. There are countries around the world who do not have life sentences and function well as societies. In Portugal, life sentences are unconstitutional sentences. You can't have one. Doesn't mean sometimes there aren't certain kinds of preventative sentences, like very narrowly circumscribed in certain particular kinds of cases. Norway has no life sentences, but I've been in contact with a researcher there who's looking at a particular kind of like a preventative DO regime type thing that they have, but they don't have life sentences. And in other countries, even if they do have life sentences, they're not mandatory. for murder. And there's a whole gradation of things we could do short of, we always like, we just look at the US and go, well, we don't do death penalty and we don't do life without parole, so we're good. But actually, we are extremely on the punitive end. We take out like sort of extreme outliers like the US, but countries we normally compare ourselves to, we are extremely punitive. Now, so yeah, 18, right? There's actually a significant movement internationally and in a number of jurisdictions to actually either raise that age to 21, or to have, or some year in there, or to have some kind of a regime that's they're called young adults, I think, young adult regimes for people who are 18 or 19 to 25 or to 21 or to 23 in some jurisdictions, and to have a different sentence, something different from true youth. And then recognizing that, you know, that what we know, that especially with the brain science, and I think the brain science stuff is very influential on those efforts. I worry though about that focus on capacity and brain capacity and all of that kind of overwhelming other factors about why we would treat young people differently, why we would not put the full force of our punishment system on their shoulders, and also that capacity issues. Many adults have capacity issues, and yet we don't have a separate regime. And I think I worry about legitimizing, like by saying these are the only people that we worry about capacity, we're going to have a different regime for. We ought to look more generally about how we have, you know, we have such limited scope within the criminal legal system to actually address issues of cognitive disabilities and those for anyone at any stage of their life. And yes, we're supposed to be able to take that into account at sentencing, but it ought to be more relevant to thinking about culpability. And I have a broader critique of our focus on punishment more generally. So I have many layers to my answer to that. But yeah, it's such a good question and such an important thing to attend to. And like I said, there is work going on. And some people in the room might know more about that, because this whole foray into looking at young people is sort of new for me. Laurent?
So I have two questions.
Oh,
The
dear.
first one is, are you worried that if there is a successful challenge, it might end up with like a response where it just gets pushed into indeterminate sentencing and dangerous offender designation as a kind of like alternative to life sentencing, and so that essentially if you get as like the current regime kind of declared unconstitutional, they'll just find another way of putting people in jail forever? First question. Second one, so you said, you know, the Crown taking it off the table has been kind of a hindrance to litigation. Should lawyers just forge ahead and try to continue to challenge even if they do that?
Well, you have a client, right? When you're a lawyer, and so you have to take instructions from your client. But that doesn't stop us thinking about public interest standing in a case like this, and other ways to get this before the court. And you know, I think we might share some interest in thinking about how these kinds of issues can be brought before the court in a case where it's quite thoughtfully argued. You have the relevant, like the resources and the people working pro bono to do to have expert reports and all the stuff that you might need to actually to file a constitutional challenge. So I answered the second part sort of first. On the first question, like the deal regime is also problematic, and I don't think that's not my biggest worry about what would be replaced if this regime was found unconstitutional. It would really depend on the nature of the finding of unconstitutionality. Like I said, if it's that gap problem only, then I think it could very well be filled with a range of quite lengthy possible determinate sentences for young people, and in an adult prison, which I don't think is a good result. I mean, it does save some young people, but from being under a life sentence. Like people like James for sure, and lots of people would have preferred if they did their time and then they could actually get on with their life after serving their sentence. So that would be maybe better to some extent, but it would sort of, it would create sort of additional problems, I think. And it wouldn't get at the sort of fundamental issues about why we insist on trying to remove childhood from these young people. Why do we insist on seeing them as not immature anymore? Because it's the nature of the offense just totally overwhelms the analysis. And it does so in a way that I think is quite unprincipled with the presumption. And it goes back to that compromise in the first place of we recognize that you know, there's all kinds of really good reasons why we treat young people differently in terms of socially, how young people, you know, are, you know, I mean, children don't have many rights, right? Like, I mean, notwithstanding, you know, great professing of the rights, there's lots of ways in which we only need to look right now at what's going on in Saskatchewan with the you know, parental rights law, right? And so, you know, I think I might be losing my train of thought there, but just that I think we need to pay attention to what's going on here and why there's this insistence on, you know, on trying to like take these kids out of childhood and be able to punish them fully. But I do think, like, in terms of those issues, that's why I have two papers here, actually. That there's the one paper where I'm looking more at these themes and kind of as a theoretical issue and trying to get at some of those issues. And then I have another paper on the constitutionality that I actually haven't done more than sketch out yet. The first one is pretty much done. And so I do think those are kind of two different things. And but obviously they're connected. Who else had a question? There was some. Oh yeah.
So talking about the appetite for change, I mean, I think you've identified part of our problem is the nature of the offense really overwhelms everything. And we have this really cognitively dissonant way that not just judges, but sort of society at large talks about victims versus accused. If you've got a 15-year-old complainant in a sexual interference, they talk about her as if she's a child, almost to the point of infantilization.
Yeah.
Meanwhile, a 15-year-old accused who commits a convenience store robbery, oh, you know what you're doing at that age. You're almost an adult. Like, don't tell me that's not a grown-up, right? And the Supreme Court of Canada refused to even impose a lower presumptive ceiling under Jordan for youth in KJM in 2019. So I'm just wondering, like, is there really appetite for striking this down?
No, I mean, and you're the one. Susan's a former student of mine, but is working, you know, in this field and would know more about some of those really particular challenges. So yeah, I think it would take, as with many of these things, you know, kind of the right case, the right intervention, right work, and trying to kind of push this through to the extent that we think we could do this under the courts. I think it's well, look at what's going on right now with bail reform, right? You get one high profile case of, you know, not with you can have all the stats you want about bail or parole, people on parole and all those things, but then you have one high profile case and you have, I'm in a province with an NDP government, and you have them jumping on the bandwagon for more you know, punitive bail laws. And so I have no, like, the political process would have to be like some kind of stars would have to align to change this through the political process the way things are right now, which is why I do think the court sometimes can probably, like, Bissonnette was never going to be changed through the political process. Like the Liberals weren't going to be like on the hook for you know, respecting the rights of multiple murderers, right? Like that was not who they were going to be. That we weren't going to do that. It took the Supreme Court to do that. Again, I'm not like the judges are the heroes here, and this is what we need to, like, every social problem has a constitutional answer. Like, that's not what I'm saying, but I do think sometimes you can, within these areas, in the area where I work around people who are incarcerated and criminalized, sometimes the courts are a better option. But you need to also be very careful and thoughtful about that, because you don't want a really bad precedent either. Okay, yeah.
Do judges ever grapple with the fact, and that was something that struck me with the quote at the beginning, right? The 17 term going on 23, with the fact that their stories of maturity are in many ways stories of immaturity. Right?
Yes.
Essentially, this idea
Yes.
of like rebellion from the family
Yes.
as a form of differentiation and individualization, that and then criminality as part of kind of leaving a nest and finding a new family, and only kind of later through the process of maturation going back to perhaps a both more community driven.
Yes.
Yeah. Like these seem like stories of kids. Yeah. Yeah. And you can totally see the narrative that way, right? Like, and that's actually more evidence based, right? It's just simply not the case that that someone who is you know, like the 15-year-old case is this one of the ones that haunts me the most. Like reading these cases is hard. Horrible things have happened, and so I always want to make sure that I'm not seen as ignoring in any way the fact that someone lost their life, and it's often in really horrific circumstances, and all that, and that we as a society need to do much better. And the legal and you know, our system of supports for people who are victimized and their families are not good. The answer we give is go for justice in the courts, as opposed to, you know, what other ways that people might need support when they've experienced that. But this one case involving the 15-year-old, I think I say girl in my, you know, 15-year-old young person in that case, she got convicted of first-degree murder for encourages, essentially the evidence at its highest was that she masterminded and encouraged her boyfriend to kill this other girl, this other teenager that he'd been in a relationship before her. And she did absolutely no steps toward it. It's an incredibly, like, it's a rich text for a critical gender analysis, let me tell you, of how she is seen as incredibly mature as a 15-year-old who, you know, was, you know, saying whatever she was saying on her text to this this boyfriend. And obviously a horrible thing happened, and I don't in any way deny that, or it's just what is the public interest in coming down on her in the way that we have. She's still it wasn't text, I think it was before texting, but it's like it was messages or phone messages, I think. But in any event, she's you know, she's still in prison past her parole eligibility. I know from advocates who work in that area. And you know, she had a horrific time in her first like 5 years inside, and she had to like everybody has to harden themselves. Like these young people who go in like on these sentences, they have to become, James speaks about this, you know, having to, you know, they're you know, it's a very hard thing to navigate, and then to how do you survive that, and how do you then get yourself, you miss so much, and then you need to get yourself out on parole. In any event, I'm not sure I answered the question, but these narratives of mature, like it's really problematic, I think. But again, like the offense just weighs so heavily in these cases, and yeah, and tends to overwhelm. But I do think it's also like the advocacy sometimes can get a different narrative, and that maybe a judge that might be receptive to a different interpretation of those facts. But yeah, this narrative is often pushed that this shows that they're mature, and that they therefore, it's just kind of surprising that in so many of these cases we have young, the presumption being rebutted. I don't know. It's not what people thought was going to happen, or said they thought that was going to happen. Yeah.
Was the girl in question Indigenous in this situation?
I don't believe so, actually.
Oh, okay.
At least it wasn't mentioned in that case. But this is kind of gets at your point too, Susan, about, you mentioned that how you know, people who experience, young people who experience you know, sexual assault, or are the complainant in those cases, are sometimes, you know, really described as children, and sort of infantilized in a way. But there's also some of my colleagues who work on sexual assault said, when I was talking to them about this work, that they see a narrative around some victims, especially, and often racialized Indigenous, Black girls, teenagers, who are complainants in sexual assault cases as also mature, right? And as also, you know, knew what was going on here, and of course they consented, and like, so there's ways in which we see the kind of denial of childhood to, and it's a very racialized phenomenon, but also can be, you know, can also be like, it doesn't, because it's racialized doesn't mean it only happens to young people of color, but it's a very kind of significant theme that I saw in these cases. Yeah. Are we at time? Yeah.
Unless there was one, I think I saw one more question here. But
Did anybody online have questions? No.
No question.
Okay.
did you want to ask? That's a
Yeah. Sure. I'm wondering, in your research, do the judges grapple, like the ones that impose life sentences on you, do they grapple with the fact that for young people, they're serving harder time, and that life is relative on average? If you sentence a young person to life, the sentence is much longer.
Yeah.
Do they grapple with that?
No, in fact, like I said, it's like, I feel like the life part of the sentence is invisibilized, normalized. Like it's the idea is that they're going to federal prison, and we've just, like, the youth system, this short sentence that they're going to get, it's not that short really, like, 7 or 10 years. And the idea of, you know, particularly tailored interventions for young people. Again, people who work in the field can, you know, probably prove me wrong that those are useful interventions in some cases. And I suspect there's lots of issues there, but at least in terms of, they are focused on, you know, young people, and they are not, you know, they're not meant to be as, punitive as adult prison. But there's this sense that if they're not long enough, and if we've decided this person is more mature, they need what the adult prison offers. They need the programmings and the rehabilitation and all the great things that Correctional Service of Canada offers, like on their website. Like, you can go look, it's there. Whether they're actually going to get that on the ground, which the correctional investigator says that they do not, because there's huge issues with the young people sentenced to adult prison being really having their interests ignored. This is a huge issue with lifers generally going in, is that when you go in on a life sentence, you are like lowest priority for every program. You are like nothing is tailored for you because you aren't anywhere near your release date, and the resources, to the extent they are provided inside for, you know, getting your programs and correctional plan, the boxes checked on that to get yourself ready for going up before the parole board. Those resources are all focused on people who are closer to their eligibility date. And what happens is, lifers don't get that at all. And so, and if you're a young person, even more, the programs are just not tailored at all. I have lots of critiques of correctional programming generally too, but even like these are particularly not, and it's been quite a theme that the OCI has commented on in his reports. We have to end, I think, right? Yeah.
I mean, if it was up to me, this could go on for a few hours, but I think maybe we let people go.
Yes. Let people go have their lunch.
Yeah, but thank you so much for doing this. This was so enlightening. So much of this information, as you said, is not publicly available, or very difficult to kind of coalesce together to be able to see kind of those bigger picture things. So thank you so much for being here and sharing that with us. And I just wanted to thank the Alberta Law Foundation and the University of Alberta Faculty of Law. I also want to thank my colleagues, Richard Maley, for doing, the director of the center,
Yes.
Doing the tech for today, running our tech and helping with this event. And Julie Meehan, who had to just run out, but she's our administrator, and she does a lot of hard work putting this together as well. So thank you all for coming, and hopefully we'll see you at some other events.
Thank you all. Yeah, it was really great. Great questions, and lots to reflect on, lots more work to do. So thank you all.